Hello, everyone. My name is Sam Sutter. I'm the District Attorney of Bristol County, and thank you for tuning into my show, In the Spotlight. This month, In the Spotlight, we'll be focusing on domestic violence. And I'm very fortunate to have with me an acknowledged statewide expert, the Chief Domestic Violence Prosecutor for the Bristol County District Attorney's Office, formerly the Chief Domestic Violence Prosecutor for the Plymouth County District Attorney's Office, Courtney Cahill. Courtney, welcome. Thank you very much for taking time out of your busy schedule and coming to the show. This issue is front and center this week. We're taping on May 30th, and the issue is front and center because Jared Remy pled guilty on Monday to first-degree murder in the slaying of Jennifer Martell. So Jared Remy's plea to the slaying of Jennifer Martell, the pending legislation in the legislature, domestic violence is front and center. How did you get involved in this cause?
When I graduated from high school, I started an internship with the Norfolk County District Attorney's Office. At that point, it was William Delahunt. When I was working there, he had a national model program for the prosecution of domestic violence. It was spotlighted all across the country, and it was something that I got involved with through that program because I wanted to be a member of that national model program.
And so following up on that, what took place next in your career?
I stayed with the Norfolk County DA's office till 1999, from 93 to 99. I then became the special sheriff of the Norfolk County Sheriff's Office under Michael Bellotti for 3 years. And in 2001, I went to the Plymouth County District Attorney's Office and was the chief of their domestic violence unit there.
Did you focus in on that right away when you went to Plymouth in 2001, or did it take some time before you started to head up that unit?
Nope, I was hired by District Attorney Cruz to head up their domestic violence unit.
And what, tell me if you would, what changes did you bring to the approach to domestic violence prosecutions in Plymouth?
Well, I think that we just expanded on the programs that were already there, expanded our high-risk safety first teams, expanded police training, wrote grants to get money, to bring money into the county to train our officers when responding to domestic violence, and really focused our assistant district attorney and advocates on vertical prosecution and proceeding without the victim, what's called an evidence-based prosecution.
So we're going to come back to that when we talk about what you're doing here in Bristol County, what's taking place statewide. I want to, at this point in time, return to the Jared Remy case. So last week, as I said, we're taping this on Friday, May 30th. Last week, Mr. Remy came into court for the first time in close to a year. Commentators noted that his appearance was changed. He seemed slimmer. He was there. There were conferences taking place between his lawyer or his lawyers and the prosecutors, and then the case was rescheduled for this Tuesday, May 27th. And then on that day, he pled guilty to first-degree murder. Did that surprise you?
Although it's very rare to see a defendant plead guilty to first-degree murder, it did not surprise me. The dynamics of this case, they had some overwhelming evidence of the actual murder. They actually had witnesses there that witnessed the murder, tried to stop the murder. So I think the evidence was strong, as well as there has been speculation he did it to protect his family, he did it for his child, he did it to protect his mother from having to take the stand, because there was different talk about her asking the victim not to go forward on cases, not to go forward on restraining orders. But in speaking with a colleague this morning, I think he had a better point, is that it's not surprising because Jared Remy is a batterer. Battering is about manipulation, battering is about control. And by pleading guilty to first-degree murder, he is taking control of the situation, and he is saying, nobody put me in jail for life but myself. I did it. Nobody did it to me. So I think it was a continued control issue that he had over the system.
But you and I have both seen, you've been a prosecutor since the late 1990s.
The early, unfortunately.
Well, that's right. 99 you became a special sheriff, so you
Yes.
started in
93.
93. So I started as an assistant district attorney in 1991. So I think it's accurate to say that both of us have seen stronger cases than the Commonwealth's case against Jared Remy go to trial on the issue of whether it's a first-degree or a second-degree murder. So to that extent, I was surprised. Explain to our viewers what the difference is in a case like that between a first-degree conviction and a second-degree conviction.
The difference between first degree and second degree is the punishment. A second degree, you get a life sentence, but you're eligible for parole at, I believe, 25 years
Now.
And which recently changed from 15. And with a first degree, it is life without parole. So there's no chance of getting out.
But with respect to the proof, tell our viewers what the added element is for first-degree murder that does not need to be proven by the prosecution for second-degree murder, and then I'll ask a follow-up question to that.
First degree murder, you have to prove premeditation, which does not have to be specific planning, whether it's, an hour, a day, a week before. It can be a snap decision, 1 second, or it could be with extreme cruelty and atrocity. And I think they had both of this in this case. According to witnesses, she was stabbed several times. And then he continued to beat her, knocked her unconscious, and continued to stab her after that. So I think you had the extreme cruelty and atrocity as well as the premeditation, because as he said it, he didn't like that she broke his rule about taking his child away from him, and he killed her because she broke his rule. That right there is enough for premeditation.
It was almost shockingly revealing that he said that. When you have somebody with that pattern of abuse and battering to talk about her breaking his rule, which is, I think, something he said at the plea, correct?
He did.
Which was even more stunning to me than the fact that he did plea. I thought to myself, somebody that arrogant, which he clearly is, would take the case to trial, because literally a person pleading guilty, who's facing a first-degree murder charge, has nothing to lose by taking it to trial. If they lose the case, it is life without parole. If they plead guilty, it's life without parole. So that's why I thought someone that arrogant would definitely push the case to trial. But then to plead guilty and say she broke my rule, once again, you're more of an expert than I am. That probably didn't surprise you as much as it surprised me.
It did not surprise me. He still wanted to control, he still wanted to manipulate the system and blame the victim for her death. That's what he did. He said in his plea colloquy, I told her she could always leave, but she could never take my child. She broke that rule by threatening to take the child, so I killed her.
So let's talk about what we can do about this enormous and sweeping problem. And I'd like to begin by discussing the magnitude of the problem. So, domestic violence. I think in the public's mind, when they think about domestic violence, they think about the battering of a woman by a man. But the reality is that there are cases of domestic violence where the man is the victim. Not nearly as many, but they exist. Talk about your estimate of the numbers of domestic violence cases, the percentage breakdown, men against women, women against men.
Okay. Well, the Department of Justice and CDC give us an estimate that either 1 in 3 or 1 in every 4 women are going to be affected by domestic violence sometime in their lifetime. As far as our prosecution of domestic violence cases, I would say about 90% of our victims in prosecution are females, with 10% being males. But I would like to say that I think that the numbers are skewed because there are a lot more males out there that are being abused at home by wives or girlfriends. But the barriers to them reporting it are very difficult, and I think that's why our numbers are skewed. But I do believe the majority of victims are females, but there are more male victims out there that we don't know about.
Well, let's focus on the females
Okay.
in this show, because my experience as a prosecutor in the district court and the superior court was, although not as extensive as yours with domestic violence, I had the same perception. I would have said even higher. I think of the cases I prosecuted, probably 95% were cases involving men battering women. So just thinking off the top of my head, if Massachusetts has somewhere over 3 million 3 million women, and we've discussed that the battering can begin as early as teenage age.
Absolutely.
So that's 13. So over 2.5 million women in Massachusetts, either teenage or adult women. And the estimates nationally are between 1 in 3 and 1 in 4 will be subjected to battering, subjected to abuse at some point in time in their lifetime. How many of the cases, your estimate, and to what extent is this based on some kind of study, where there is battering, are reported to the police and go to court? Reported to the police, let's say. How many cases, what's your estimate of the incidents of domestic violence that get reported to police?
And I don't have a perfect study for you, but in my experience in prosecution and working with the safe plan advocates at the courthouses who assist victims in obtaining restraining orders, I would say about 50% of all victims are reporting this. And we know this because there are many victims that go to safe plan that get restraining orders that never report it to the police department. So that's where my figure comes from. But I would say about only 50% of those being abused actually seek help from law enforcement.
So that's a better way to look at it. I was thinking about it in terms of incident by incident. You're thinking about it in terms of victims. So that's a very worrisome statistic to me as the district attorney, is that only half of the victims are reporting. Let's focus on that for a moment. What can be done to improve that situation? Before we get to all the problems that take place once the case gets to court, which we will probably in the second half of the show. But let's talk about that. That is a very disturbing statistic, is that only half of the victims are reporting. What can be done and what is being done to dramatically improve that?
We as a society need to take the stigma away from the victim. We blame the victim. Why doesn't she leave? It's the offender's behavior that needs to be changed, not the victim. So we as a society need to take the stigma away from a victim and make it okay that they feel comfortable reporting it. And to take that stigma away, what we need to do is we need to educate. We need to start educating in our elementary and junior and senior high schools. We need to start educating our community as a whole to what domestic violence is. It's not just physical abuse. It's emotional abuse. It's verbal abuse. And we need to educate them about how many people are victims and make it so it's more comfortable for victims to come forward to report it to police. Take the scarlet letter away.
One of the ways we reduced gun violence in Bristol County, and the same approach was taken to reduce drunk driving throughout the state and throughout the nation, was public relations campaigns, publicity. So we had signs on the back, with respect to gun violence, on the backs of buses saying that you were going to go to jail if you were carrying an illegal firearm on the streets. I was on the radio all the time talking about it. Do you think enough is being done to publicize the problem so that women who are being abused feel more comfortable coming forward?
No, we need to do more public campaigns out there to say, it is not your fault. We are here to help you. And we will help you if you come forward. We need to educate our community about neighbors. You hear violence in the home next door, you need to pick up the police and not be a silent bystander. We need to stop the silent bystander so that people do get involved in those households so that we can get the violence to stop.
Now, when we come back after a short break, we'll be talking about what happens when the case goes to court, and what the legislature may be doing about this problem before the end of the legislative session this July 31st. Please stay with us. Back in a moment.
Why doesn't she just leave?
But he's such a nice guy.
He said he was sorry.
We don't talk about that.
It's just the way people are.
We're never going to fix it.
No more excuses.
No more silence.
No more violence.
It's time to end domestic violence and sexual assault once and for all.
Hello again, everyone. Thanks for staying with us. My name is Sam Sutter. I'm the District Attorney of Bristol County, and thank you for tuning into my show, In the Spotlight. This month, the spotlight is on domestic violence, and what better person to talk about the issue than the chief of my domestic violence prosecution team, Courtney Cahill, who previously was the chief of the Plymouth County Domestic Violence Prosecution Team. Courtney, thank you so much for coming on board. We're having an interesting discussion. And just before the break, you were telling our viewers that half of the victims of domestic violence don't come forward, but half do come forward. And that, we estimate, leads to approximately 30,000 cases statewide of domestic violence each year. About how many of those each year in Plymouth County?
We had about between 3,200 to 3,300 domestic violence cases that were arraigned each year in Plymouth County.
And in Bristol County, it's about?
Since I got here, I've estimated it's about 27, almost 2,800 cases were arraigned in 2013.
So between Plymouth and Bristol, about 6,000, statewide 30,000, and our viewers may be very dismayed to hear this and even stunned to hear this. How many of those 30,000 are getting dismissed, according to your estimate?
According to my estimate of working in the district courts daily, I would say 60 to 70% of those cases are being dismissed.
Staggering and unacceptable, 60 to 70%. Now, my experience is that the cases are dismissed generally because the victim no longer stays interested in the prosecution and therefore either does not show up for court when subpoenaed for the trial, shows up and tells a very different version from the version that was told to the police on the night of the incident, shows up and says that she, or in some instances he, started the fight and therefore invoke a Fifth Amendment privilege, refusal to testify, or if married, invoke the marital privilege. So 60 to 70% of 30,000 getting dismissed, and most of those because the victim no longer is interested in the prosecution. What can be done about this problem?
Well, again, we need to change the thought process that it's not the victim's responsibility to prove our cases for us. It's our responsibility to prove our cases for us. The first thing that can be done, when a victim calls the police, they're calling for help, they want the violence to stop. Once the police get there, the defendant's been arrested, they've accomplished their goal. The violence has stopped that night. As we move forward into prosecution, a victim might be on board at first, but then for every victim I've worked with, there's 100 reasons why they choose not to stay with prosecution, whether it's financial, love, fear, threats.
Let's talk about those individually, though. So financial meaning what?
Financial, the defendant is locked up or has been ordered to stay away from the victim, and the defendant, if he's locked up, might not be employed, and that victim and those children in that house rely on that defendant's paycheck to keep a roof over their head, food in the refrigerator, and clothes on their back.
It's interesting that you led with that, because I thought you would have led with fear, but talk about the fear. And why did you lead with financial?
Because I have found that's one of the biggest reasons why victims do not want to go forward, because they think by going forward in prosecution, the defendant is automatically going to jail, and therefore they won't be able to financially afford their homes, their apartments, and the things they need for themselves and their children.
What could be done about that within reason, within the constraints of modern-day state budgets and federal budgets? What could be done about that situation?
Well, the first thing we need to do, we talked about that campaign, educational campaign. We need to educate our victims that there are agencies out there, and I know that we're going to post them here if anybody is in need of help and assistance from our agencies, but there are local service provider agencies in our communities that can help with sheltering, can help with housing needs, can help try and get money to pay oil bills, electric bills, rent and mortgage, and our victims don't know that. So we need to do a better job in that public awareness campaign of educating the resources that are currently available.
I very much agree with you on that. So, and then the next one is fear. That's the one that I saw over and over again in the district and even in the Superior Court. Talk about that.
Well, a victim is afraid to go forward because the defendant might be intimidating her. If you go forward, there is going to be a another physical assault against them, might be threatening to hurt them, their children, their family members. You also have not only the defendants threatening these victims, but the defendants' families, defendants' friends. We have unfortunately, a lot of our defendants are involved, have gang affiliations, and those people, associates, are threatening our victims. So they just have a fear of, if they go forward, we can't guarantee it's a guilty. We can't guarantee if it's a guilty that the defendant's going to jail. So if it's a not guilty or the defendant's out and she goes forward and testifies, is he going to follow through on those threats?
Sounds like better interaction, better publicizing of what we're trying to do can also do something about the fear factor.
By educating the victims about the court process, by educating the victims that when we do go forward, it's not always he's going to go to jail, but it's a batterers program, it's substance abuse, it's mental health counseling that can assist the defendant in changing his treatment of the victim so that the violence in the home starts. And that's where we in the office and the domestic violence unit are really focusing on our victim witness advocates getting in touch with the victim the day of arraignment, making a relationship with these victims so they understand the system, they understand what resources are out there for them, and what we as an agency of the district attorney's office can assist them to continue with prosecution.
How about perhaps the most difficult factor of all leading to someone not staying with a domestic violence case, the victim not staying with the case, and that is what I believe you said was the love, dependency factor. Talk about that one.
You have to remember that these people once loved each other. The relationship, and in most domestic violence relationship, the abuse doesn't start until they are in a committed relationship. And at that point, the defendant acts violent and then apologizes. It is a cycle. Every day in a domestic violence relationship is different. They're not always bad days. There are some very good days in these relationships, and the victims rely and remember on those days that things can get better. There are promises, I will change. There are promises, it'll never happen again. And when you're in love with someone, you might own a home with them, you have children with them, you want to believe that.
So there's more focus on this problem right now because of what took place with the famous athlete's son in a brutal slaying. My tough question for you is the problem getting better? And I was somewhat surprised by your answer off the air, because you're going to say it's not necessarily getting better, and you traced the reason why it's not getting better to a Supreme Court decision that came down within the past 10 years, which made it more difficult for us to prove cases without the victim's help. And that case is?
That is Crawford v. Washington, and in Massachusetts it was interpreted by our SJC in Commonwealth v. Goncalves.
And that changed what prosecutors used to utilize, the excited utterances. So the police show up, and the victim blurts out what just took place. He just hit me right in the eye, or he hit me over the head with the phone, or he slammed me into the wall. That evidence, back when we started as prosecutors in the 90s, that came in. And that was often all that you needed. If you had the police, the observations, the excited utterance, you stood a very good chance of winning the case. Then the Supreme Court said what?
Well, that was when the victim didn't choose to testify. We could go forward with just our police officer. They, because of this, it's called the Confrontation Clause. The defendant has a right to confront their victim.
It's constitutional.
Yep. What the SJC said is those excited utterances to the police officer are no longer available for us to use in prosecution if the victim chooses not to testify.
Unless it's for medical treatment, right?
Well, they've actually changed it. They've given us three avenues to use excited utterances. If the excited utterance is given to a non-police officer, a neighbor, a relative that might be present, as well as if the statement is used to quell a volatile situation, their language, quell a volatile situation. So if somebody calls 911, Robbie's hitting me over the head with a beer bottle, please come fast, then we can use that 911 tape to prove our case. And finally, if the statement is given for the treatment for medical treatment, exclusively for medical treatment. So when an EMT comes to treat the victim, those statements to the EMTs are now used as excited utterances. And you will see us, we've done recent training in the office, you will see us as prosecutors using civilians, neighbors, family members, 911 call takers, and EMTs to prove our case, because remember, it's our job to prove our case, not the victim's job.
So with the limited ability that we have now since the United States Supreme Court case and the state Supreme Court case to use excited utterances, what more can be done to win more cases where the victim is not cooperating?
Well, there's another a rule that we use, evidence-based rule. It's called forfeiture by wrongdoing. If the defendant interferes and makes the victim unavailable to us, either by promises or threats.
Not forfeiture of property, but forfeiture of?
Forfeiture of the right to confront this witness. Right. If the defendant makes her unavailable to us, all those statements to the police, the hearsay statements, will come in through the police officer. So what we're doing is we're listening to jail calls, a lot of jail calls. We're listening to defendants convince victims to write us affidavits. We're listening to defendants convince victims to not go forward and to ignore the summonses.
All of which require greater resources, though, more personnel. So it's almost as if we have some ability here to improve the situation, but we're going to need more resources to do it, which gets to the legislature. With the Jared Remy case front and center, the legislature acted, and pieces of legislation which were not moving forward now appear to be close to becoming law. Two that I'm thinking about are the elimination of accord and satisfactions. I'm going to ask you about that, and a strangulation, a separate strangulation statute. I'm going to ask you about that. So, accord and satisfactions. One of the banes of prosecutors ever since we got out of law school, and I got out before you did. And tell our viewers quickly what an accord and satisfaction is and how they were being used by defense attorneys.
In a domestic violence case, in a misdemeanor case, which
is
an
assault
and battery,
right.
Violation of restraining
Right.
order, threats, a victim can sign a piece of paper that the defense attorney types up and provides to the victim that they want the case dismissed because they have been satisfied with an apology, a dinner out, flowers, whatever the satisfaction might be, so they no longer want to go forward with the case.
Could I have that little piece of paper there that you have on it? So it used to look like this, viewers. It'd say accord and satisfaction. And when I started in Fall River District Court in 1991, they were very common.
Like playing cards given out. And we have no say. The judge can take that accord and satisfaction. Even if we can prove the case with excited utterances without the victims, judges can dismiss it. We basically have no objection, no say in that accord and satisfaction.
And now, if this bill passes both the House, which it has passed, and it's now in conference committee with the Senate, passed by the legislature, signed by the governor, what's going to happen to those little pieces of paper?
They will no longer be allowed to be used in domestic violence cases.
Which will be a tremendous advantage for prosecutors and for victims in domestic violence prosecutions. So now the strangulation bill. I read many times, especially in the wake of the Jared Remy slaying of Jennifer Martell, that strangulation is often a precursor to an even more violent act, such as attempted murder. And yet prosecutors have lacked the ability to charge someone who puts their hands around another person's neck and strangles with anything more than assault and battery. You could charge with assault with intent to murder, but you have to prove that the person charged intended to murder. So that's not easy to do when the victim lived. What's going to happen if the strangulation bill passes, Courtney?
I am so excited for the strangulation bill. I actually helped write it years ago, and what's going to happen is we are going to be able to, if somebody tries to suffocate or strangle somebody, we are going to be able to have that as a separate charge where we can prosecute it in district court and with a 2.5-year penalty in the House of Correction, or we're going to be able to indict these offenders and prosecute them in Superior Court and send them to state prison for the strangulation.
Which I'm looking forward to with great anticipation. Let's hope that the legislature does act between now and July 31st. I think they will, with both eliminating accordance satisfactions and passing a strangulation bill. Next month, I hope to have you back. We're going to be talking about prevention, and I will have with me Dr. Jay Shackney, who started the Katie Brown Domestic Violence Prevention Program. So thank you for tuning in. Look forward to seeing you next month. So long in the spotlight with Sam Sutter.